I'm the Dean of the College of Law, Lou Bilionis. It's my pleasure to welcome you to the Harold C. Schott Scholarship Award Lecture. As many of you know, quite some time ago now, the Harold C. Schott Foundation established a truly generous fund here at the College of Law to support faculty excellence and faculty development. Since its inception, the Schott Foundation's fund here at the college has supported outstanding research and scholarship by our faculty in a wide and diverse range of areas. And it's been instrumental in strengthening the faculty and our school, instrumental in bringing strong faculty to Cincinnati, instrumental in keeping them here, and also instrumental in fostering the kind of culture we want to have here, a vibrant culture of intellectual inquiry from which we all benefit. In addition to directly supporting faculty research projects, the Schott Foundation's fund here at the college also provides for special recognition. It provides a scholarship award to be awarded to only one faculty member per year if warranted, and we don't give it every year, for outstanding research and scholarship achievement. And this year we have a truly outstanding and most deserving recipient of the award, Professor Kristin Kalsem. Now, I thought with some joy about how I would introduce my friend Kristin, and I could say so much, and I could run through the amazing accomplishments and credentials, many of which you all know. What I would say, though, from the heart is, we're going to hear from someone who really does it all, and does it all so very, very well, and does it all with amazing grace at the same time. She is the Charles Hartsock Professor here at the College of Law and also a co-director of the Center for Race, Gender, and Social Justice. She's been deeply involved with the joint degree program in law, with law and women's gender and sexuality studies. She's an award-winning teacher. She is a marvelous colleague whose wisdom and cheer is never failing. And she's also a hell of a scholar. Her 2012 book, In Contempt, 19th Century Women, Law and Literature, is a terrific work that brings together law and literature and feminism to illuminate how 19th century women writers advocated legal issues in their literary works and in their lives as authors. The kind of work that we aspire to produce here at the College of Law, interdisciplinary, illuminating not only the past and the present, but also inviting you to think about how one might change the future for the better. It's what we expect from someone like Kristin, to the point of being unsurprised, but nonetheless tremendously grateful. She is recognized nationally as a productive and insightful scholar at these intersections of law and literature and feminism. And at the same time, many of you know her as your bankruptcy professor, putting you through your paces in an important area as well. Today, we're going to be hearing from her with a lecture that is derived from her book, I guess, and her ongoing inquiry. From Wuthering Heights to our own West End. Doesn't the title tell you something about her span? Women's writing, women's advocacy. Please warmly applaud our colleague and friend and teacher, Kristin Kalsem.
Thank you for that really kind introduction. So since I'm wearing something that doesn't allow for the microphone we usually use in here, I can't clip it on. Can you all hear me with this? Okay, not really? I'm going to get this right because I don't want to fuss with it. Okay, now can you hear me? Yes? Okay. All right, well, I just wanted to say before I start that I'm really honored to be in the company of my colleagues who have been awarded this prize and given this lecture in the past. I see some of them in the audience. These are colleagues whose scholarly careers I deeply admire, and I am just thrilled to be in that company. I also need to give a special thanks to Mindy Lawson and Jen Cuesta, who are responsible for helping me make this presentation both more substantively rich and definitely more aesthetically pleasing. So going to begin this lecture as I begin my 2012 book, In Contempt, 19th Century Women, Law, and Literature, by discussing a scene from Lewis Carroll's Alice in Wonderland. Alice, in her final adventure, becomes increasingly bold during the trial to determine who stole the tarts of the Queen of Hearts. As you may recall, she had become very small during her travels down the rabbit hole. But at the trial, she experiences that curious sensation and realizes that she is growing back to her true size. Despite the Dormouse's warning that she has no right to grow here in this court of law, Alice decides to stay. And what a spectacle she makes of herself. She is loud. She literally upsets the jury. She interrupts and talks back to the judge. In fact, she shows no respect for the stuff and nonsense of the law itself or any of its representatives. "Who cares for you?" said Alice. She had grown to her full size by this time. "You're nothing but a pack of cards." At this, the whole pack rose up in the air and came flying down upon her. As Alice comes into herself, chaos becomes the order of the day, and one senses that Wonderland system of justice will never be quite the same. In this closing episode of Alice's adventures in Wonderland, Lewis Carroll dramatizes what by 1865 was to become an increasingly popular Victorian scene. A woman questioning and critiquing the law and claiming a place for herself within its institutions. The first half of the reign of Queen Victoria witnessed Caroline Norton agitating for a mother's right to custody of her children and making minor inroads into a father's absolute rights to custody with the Infant Custody Act of 1839. In 1854, Norton, in a pamphlet entitled English Laws for Women in the 19th Century, put on display the harsh realities of coverture, the common law legal fiction that provided that upon marriage, the wife's legal identity was completely subsumed into that of her husband. The two became one, but that one was the husband. This also had very material effects in that a wife could not enter into a contract, she could not make a will, she couldn't sue on her own behalf. She had no recognized legal identity. I always tell my students to pay attention to how many Victorian heroines inherit a little something from a spinster aunt. That's because as an unmarried woman, the much maligned spinster had control of her own finances, and importantly, she was able to make a will. The heroine's own mother would not have been able to do so. I also tell them to pay attention to how many orphans there are in Victorian fiction. That's because so many women died in childbirth, and as I discuss in detail in my book, with no birth control, women had children every 1.5 to 2 years through their entire reproductive lives. Extremely large families were just the norm. Think of the mother in Jane Austen's Fanny Price in Mansfield Park, who gladly sends one of her daughters to another family as she prepares for her 9th lying in. Barbara Lee Smith went much further than Norton in her 1854 publication, A Brief Summary in Plain English of the Most Important Laws of England Concerning Women, making clear that coverture must be completely abolished for there to be any possibility of equality between men and women. Norton, Smith, Bethy Parks, and Mary Howitt were among a group of women active in the mid-1850s, debates concerning married women's property and divorce law reform. All were greatly distressed by the Divorce and Matrimonial Causes Act of 1857, which although it had made progress, before that time you actually had to get a specific act of parliament to divorce, so it would be the two people who everyone was discussing whether or not they actually could get divorced. This made it possible to not have to get an act of parliament, but it legislated a double standard. A man, to obtain a divorce, just had to prove adultery on the part of his wife, whereas a woman had to prove infidelity on the part of her husband, plus incest, bigamy, gross physical cruelty, desertion, sodomy, or bestiality. So just infidelity was not enough. And that's the actual terms in the statute. It's really fun to read some of these old laws in case it's not fun, but interesting to say the least. In the 1870s and 80s, despite numerous setbacks, feminists under the leadership of Elizabeth Wollstonecraft achieved limited success with the Married Women's Property Act of 1870, followed more than a decade later by the much more comprehensive Married Women's Property Act of 1882. Frances Power Cobb was instrumental in the passage of the Matrimonial Causes Act of 1878, which offered much needed protection for women from domestic abuse. Victorian women were exerting much political influence and were fortunate to be helped by members of Parliament such as John Stuart Mill. However, as the century progressed, efforts were made to eliminate the need for these middlemen as women strove to impact the law more directly by voting, by being elected to public office, and by becoming members of the legal profession itself. In England, as well as the United States, the 19th century was a period of unprecedented reforms in laws affecting the everyday lives of women. Women's contributions to these changes in law, however, have been largely ignored because their work, stories, and perspectives are not recorded in law books or other authoritative sources of legal history, but rather in texts of a different kind. My book explores the legal advocacy of 19th century women writers in essays, autobiographies, and other nonfiction publications, as well as in courts of law. It also looks at another important legal forum for women, the 19th century novel. Women were prohibited from participating in the legal realm in any official capacity. They couldn't be legislators, lawyers, judges, or jurors. So they were very creative in their advocacy, making use of the public fora that were accessible to them. Today, I'm going to talk about the stories, experiences, and advocacy of a few of these women writer advocates. I characterize the advocacy as taking place in what I call outlaw texts. I use the word outlaw first because none of them are official legal text. They are out of the purview of much legal inquiry, certainly not a part of official legal history. They are, however, very much about the law. They also are outlaw because they critique unjust laws, even though they might not seem to be legal in nature at all. Many of the novels that I analyze in my book, for example, do not feature lawyers or trials. They just narrate life. Finally, certain of the texts presented in this book also are outlaw in that they imagine new possibilities for law and justice. Judith Resnick, in discussing the value of the interdisciplinary study of law and literature, explains, "I bring literature to law students to show them what lawyers cannot yet imagine, stories that the law has yet to invent, rights yet to be seen, and how to cope with problems that stymie us by their pain." In the 19th century, writers such as Jane Hume Clapperton in Margaret Dunmore or A Socialist Home invented families that were not organized as patriarchies. Novels like Florence Dixie's Gloriana included women with rights to vote and the right to sit in Parliament. A writer of books by Emily Simmons confronts the unspeakable pain of a mother's forced and perfectly legal separation from her child. Outlaw texts narrate the effects of law on everyday life, illustrating a primary form of 19th century women's engagement with the law by examining, for example, what Rosemary Coombe describes as how legal rules and practices daily influence how people act, by affecting the expectations they hold and the risks that they take. In literary scholarship, there have been very influential studies arguing that the Victorian novel was a policer of the status quo, that even novels like Dickens' Bleak House that purported to critique the law ultimately resolve everything in a way that supports the current system. D.A. Miller, in his study, The Novel and the Police, for example, says that the overt disavowal of police practices in such novels make them an even more effective form of social discipline. Similarly, Edward Said in Culture and Imperialism characterizes the novel as a cultural form consolidating but also refining and articulating the authority of the status quo. These conclusions, however, are all based on studies of very canonical and well-known novels by authors such as Dickens and Anthony Trollope. I argue that outlaw texts call for a reconsideration of the general conclusion that the Victorian novel was an aider and abetter of a patriarchal legal system. If one examines a larger pool of literary precedents, it becomes clear that many novels truly did hold the law in contempt. In my book, I look at 3 different kinds of outlaw novels. The first one's much more comfortable, especially for historians and people, probably legal people too. These are novels where the author actually states their intention that I'm writing this novel to critique the law. So we have like an author's preface or that kind of thing. Mary Wollstonecraft's late 18th century unfinished novel, The Wrongs of Woman or Maria, is a text such as this. In her author's preface, she states that she is writing this novel with the desire of exhibiting the misery and oppression peculiar to women that arise out of the partial laws and customs of society. She wanted to write a novel to reach a larger audience than she had with her famous Vindication of the Rights of Woman. She used narrative to play out what I characterize and talk about in my book as the Gothic realities of coverture, the two become one. Near the end of the 19th century, 100 years later, in 1890, Florence Dixie wrote a utopian novel, Gloriana. Dixie makes clear in her author's preface that, quote, Gloriana pleads women's cause, pleads for freedom, for the just acknowledgement of her rights. It pleads that her equal humanity with man shall be recognized, and therefore that her claim to share what he has arrogated to himself shall be considered. But there are other kinds of novels out there that don't have the author actually specifically saying this is what I intend to do. Some novels don't have that kind of direct authorial intention statement, but the law specifically is indicted within and by the fiction itself. So Jessie Phillips wrote a novel in 1842 entitled Frances Trollope wrote an 1842 novel entitled Jessie Phillips that is this kind of an outlaw novel. This novel offered a scathing critique of the 1834 New Poor Law that made an unmarried mother solely responsible for the maintenance of her child. So there was no swearing the child to someone to get the father to contribute. She was solely responsible. Jessie, in this book, is an unmarried mother falsely accused of infanticide. Unlike Dickens, however, who might keep us wondering what was going on till like the end of the 700-page novel, we know from the very beginning that Jessie didn't commit the infanticide. We know who the actual person who murdered the child is. So as a reader, we get to witness the power of legal discourse to shape the understanding of Jessie's character and to completely misinterpret her situation. The novel also presents the life experiences of a fallen woman as we see her seduction, her betrayal, importantly, her loss of employment once people realize that she's pregnant, her unsuccessful attempts to get help from the father's child and a lawyer, and the time she spends in the workhouse. The bastardy clauses of the New Poor Law are part of the text itself, with the lawyer actually producing the act. Here we have it, safe and sound, he says, patting it, and explaining to Jessie's seducer that this admirable clause in the new law has given him complete and absolute protection from any, quote, young hussy threatening to swear a child to him, unquote. Lawyer Lewis assures, we have nothing to do with facts now in cases of this sort. The law is comprehensive enough without them. In my book, I read the novel Jesse Phillips against the legislative debates that took place over these bastardy clauses. And reading the text together helps to illuminate how Trollope's novel exposes the law's cover, from coverture, to really be surveillance, its protection to indeed be for the fondly protected man, and women's madness to be genuine anger, particularly about their subordinate position under the law. Finally, I look at novels that are not explicitly about the law at all, but they critique the law with the way the story plays out. There are no courtroom scenes in Emily Bronte's 1847 Wuthering Heights, for example, but coverture and the laws relating to married women's property underlie Heathcliff's comments and actions with respect to marriage, and if you actually trace it, it's because of the laws of coverture, which he obviously knows how they work very well, that he ends up, if you remember at the end of the novel, owning everything, right? Through marriage, through having a child, that kind of thing. Similarly, Heathcliff's wife, Isabella, though from a wealthy family, has no rights at all to her child, Linton, even though Heathcliff despises and mistreats the child. At one point in the novel, after she's run away with Linton, Heathcliff comments, "I will have it when I want it," meaning Linton, and the complete and tragic truth of that would not have been lost on a Victorian audience. So those are the kinds of novels that I look at in my book. I talk about a lot of them that you have never heard of before, which I really encourage all of you to learn about because they're pretty spectacular. But I also talk a lot about nonfiction writing in the book. And today I'm going to talk just briefly about the first two and a little longer about the third, about some real life advocates and the work that they were doing. I'm going to start off with Annie Besant. In 1877, Annie Besant and her partner, Charles Bradlaugh, published a tract on birth control and sold it really cheaply so that it would be available to the poor. As they intended, they were arrested and charged with obscene libel for publishing, the actual complaint read, an indecent, lewd, filthy, bawdy, and obscene book, unquote. At the trial, the defendants served as their own attorneys, with Annie Besant arguing her own case with great skill in open court. They lost the case on the substantive issues, which was a very strange way that it ended. The jury found them actually entirely exonerated the defendants of corrupt motives in publishing this book, but because the book itself was determined to be calculated to deprave public morals, with the specific charges that were against them, they were found guilty. However, the verdict ultimately was set aside because there was an error in pleading. So on a technicality, they actually won the case. Being prosecuted in this way, however, proved a brilliant strategy for the widespread distribution of contraceptive information, moving the discussion of birth control from the publications of the radicals to the front page of the New York Times. Many newspapers printed lengthy speeches that the defendants were making at the trial, and others printed actual excerpts from that dirty, filthy book. Besant and Bradlaugh themselves published a full-length trial transcript, and that was before the times when you actually had the transcript, so they published the full version, which was fabulous for my purposes because I could see just exactly what went on through the whole trial. One of the things I talk about at length in the book is how Annie Besant kind of played on notions of Victorian womanhood, using them as she could. So she's up there talking about completely inappropriate topics for women, completely. But meanwhile, she at one point is really concerned because the light is shining in on one of the jurors' faces, and so she wants to make sure the lighting gets moved. She's also being very kind of playing that role of Mrs. Besant while she's speaking about the unspeakable in open court. So After the trial itself, the book, Fruits of Philosophy, which was in question, which unfortunately wasn't really accurate on a lot of contraceptive information, but it sold over 300,000 copies after this case went to trial. So in this respect, the trial was definitely a victory for birth control and a personal triumph for Besant. The success, however, came at a high cost. Besant lost custody of her 8-year-old daughter Mabel in a custody battle before Sir George Jessel. Jessel cited Besant's conviction of publishing an obscene book as a ground for removal of the child, stating that although the conviction was set aside on a technicality, no judge, so far as I am aware, has doubted the propriety of that conviction. He was also particularly outraged that she served as her own counsel in his courtroom. Appear in person? A lady appear in person? Never heard of such a thing. Does the lady really appear in person? As advocate for birth control and for herself, Besant was too unsettling. The law disciplined her feminist jurisprudence by taking away her child. Very different from Annie Besant is Emily Jackson. Emily Jackson was a quiet 42-year-old woman from a small village who refused to live with her husband once she realized that he had only married her for her money. She was living with her sister when one Sunday morning, 2 masked men seized her as she was coming out of church and forced her into a waiting carriage. One of those men was her husband. Following the abduction, the carriage drove to her husband's place of residence in Blackburn, where all of the occupants went inside and the doors were locked. Emily's sisters and brother-in-law soon tracked her and demanded that they be let into the house. When they were refused, Emily's brother-in-law asked the police to break into the house and rescue the lady. Once the police realized, however, that Mr. Jackson had obtained a decree of restitution of conjugal rights, which Emily had ignored, they, quote, declined to interfere, unquote. The Times reported that there was considerable romance in the affair, and for 10 days, the more dramatic details of the case filled the pages of the newspapers. On the morning after the abduction, quote, milk and the papers were taken in by means of a string let down from one of the bedroom windows, and later on, all kinds of provisions were obtained in the same way. At noon, a box of cigars was hoisted up to the garrison. Crowds thronged the street in spite of the snow and bitter weather that year and at that time, and the police were on hand to keep order. On March 16, 1891, the Queen's Bench Division of the High Court rejected an application for a writ of habeas corpus that was filed by Emily's family, stating that, quote, though generally the forcible detention of a subject by another is prima facie illegal, yet where the relation is that of husband and wife, the detention is not illegal. On appeal, however, Mr. Jackson's arguments that he had a common law right to custody of his wife were rejected, with the Court of Appeals claiming that such an idea derived from absurd and obsolete dicta, which could not be considered authoritative in a court of justice in this or any other civilized country. As a result of this decision, which many found surprising and the legal world found shocking because, of course, this was exactly the law in England. They were just saying it kind of wasn't so, but indeed it was. Mrs. Jackson was free to return to her family. The London Standard reported, marriage, in fact, without a note of warning, has by the single decision of the appeal court been placed upon an entirely new footing. The judgment has sprung a mine upon society and destroyed at one blow the prescription of ages. Emily Jackson's voice is completely missing from the official legal record of this case. The published opinion includes detailed discussions of legal authorities and precedents relating to the husband's right to beat, confine, and imprison his wife. It also presents certain facts specific to the case based on affidavits that were filed on both sides. However, quote, the wife had no opportunity of making any affidavit, quote, because she was, of course, locked up in her husband's house. The affidavits on her side were not hers, but rather filed on her behalf. The published opinion also notes that the judges spoke with Mrs. Jackson and determined that she was indeed acting as a free agent and not under the undue influence of her relatives, but there's no legal record, however, of what it was that Emily Jackson said. Emily Jackson's voice, perspectives, and experiences, however, are documented in an outlaw text. In response to public retaliation against her, they actually burned like effigies of her in the street, by those who believed that her case had dealt an irreparable blow to the institution of marriage, she wrote a 4-part vindication that was published in the London Times, telling her side of the story. The romance of the Clitheroe abduction that the newspapers had so glamorized is nowhere to be found in her telling of the abuse that she had suffered at the hands of her controlling and violent husband. Okay, so one of the things that is just the case in trying to find out things about some women that have pretty much been lost to obscurity is it's very difficult to find things. You have to figure out kind of where to look. One of my favorite finds while I was at the British Library, you plug in any kind of term or anything that you think might actually show up, anything about them. So I had looked for a really long time on probably several trips when I was so excited to find this, which is the true story of the Clitheroe abduction, or why I ran away with my wife, which is actually her husband Houghton's response to the vindication that she published in the paper. And I mean, if it weren't so tragic and whatever, it's almost hilarious. It's full of melodrama. It's this big pamphlet. There are huge headlines, I came to claim my wife. As far as I'm concerned, really what the effect of the pamphlet was to corroborate everything that she had to say in her vindication. But there were also other items published in connection with this case. This is a pamphlet that was widely disseminated after the decision by Elizabeth Wolstenholme Elmy. And while she claims in here that the Jackson decision after it, that Coverture is dead and buried, that's not, unfortunately, is not the case. But the case really did have significant and really profound legal and lasting effects. But the person I'm going to spend a little more time talking about today is Georgina Weldon, who actually, after years, I feel like I kind of know her. She's become very near and dear to me. She was truly one of the first women lawyers in Britain, even though she was not allowed to really be a barrister or a solicitor. That didn't stop her, however, from literally arguing hundreds of cases in the British court as a plaintiff in person. This is one of the many cartoons of Georgina that you can find looking through the papers in the 1880s. Her real-life story could have served as the plot for one of the sensation novels that were so popular in her day. In 1878, 2 men from an asylum came to her house to take her away. She barricaded herself in the library and sent a servant for help. Actually, I have to say this, I don't have it in here, but I have to tell you. Meanwhile, while she's in the library, she writes a telegram to Prime Minister Gladstone saying, "You have got to do something about the lunacy laws. I have people here that are actually waiting to take me away." And this was kind of, you heard this story that she sent this telegram. Well, one time when I was in the British Library, I found everything I could find under Georgina, but I actually went and looked in Gladstone's papers, which those, of course, are indexed to like the greatest detail. It's just, okay, people like me who like study old things and like old things get excited about really, different things. I found the actual telegram that she sent. So I had Georgina's writing and it was there. Of course, I'm in some rare book room, so all I have is like a pencil recording of what it was, but it was very exciting. But of course, it's in Gladstone's papers. You have to know it's there to even know where to look for it. But anyway, she locked herself in the library, and then after several hours, the men left. She soon was to learn that it was her husband, Harry, who had tried to have her committed to an asylum for the insane. They had been living apart for 3 years, and she actually ended up being quite expensive to keep up. So he had to pay for her house and that kind of thing. She also was loud-spoken. She was eccentric. All, of course, signs of madness in women in the Victorian society. He had had 2 doctors visit her. They were people who had come disguised as people who were interested in an orphanage that she operated. These two doctors signed certifications to her insanity, and if the asylum people had successfully removed her from the house, it's likely she would have been locked away forever and we would have never heard from her again. But they had met their match in Georgina, and she began a public crusade to reform what were called the lunacy laws, telling her story to absolutely anyone who would listen. This is what she published in 1879, How I Escaped the Mad Doctors. She did public lectures all over the country. She held meetings, which she called at-homes, every Tuesday afternoon and Wednesday evening. There were little tickets to Georgina's at-homes, which included intimate entertainments at which she would sing. She was actually a professional opera singer, so she was very good at singing. And then she'd read excerpts from her book and collect money and get everyone all riled out to do lunacy law reform. Then in 1882, when the Married Women's Property Act that I mentioned at the beginning of the talk was passed, that gave married women, the right to sue on their own behalf. And she sued them all. She sued Harry, she sued Harry's attorney, the two doctors, the asylum owner, and she took them to court. Her suit against the asylum owner, Forbes Winslow, in 1884 brought widespread public attention to the need to reform the ease with which you could put somebody away. You didn't like a relative of yours who you thought might, inherit something that you wouldn't. You just had the signature of two doctors, which was all you needed to put people away. After her case, the House of Lords started looking into this issue, and when a few months later she won her highly publicized case against Dr. Semple, one of the doctors who signed the certificates, the newspaper coverage reported, "The real importance of the case is that it secures the triumph of the agitation against the lunacy laws in their present shape. Their reform is henceforth only a matter of time." The laws were changed. In anything you read about that, it was Georgina and her crusades that really brought the kind of public attention to this issue that it needed. Shortly after her legal successes, a long article and this picture of Weldon appeared in the periodical Life. Among other things, the article had high praise for Weldon's legal skills. Quote, "She has sufficiently proved the thorough soundness and clearness of her mind," which of course was hugely important to her to have that publicly acknowledged, "by arguing difficult points of law in a manner which has won her the highest compliments from the judges and which will cause her name to be handed down in the law reports, together with those of the greatest lawyers now practicing." Quite the character, Weldon is described in this article as a self-made legal Donna Quixote, and the accompanying illustration shows her dressed up, as she often did. She gave public readings everywhere. Here she's dressed up as Dickens' famous lawyer from the Pickwick Paper, Sergeant Buzfuz. This is who she is. But rather than letting comic representations detract from the seriousness of her endeavors, Georgina made them work for her, making the most of the crossovers between the discursive fields of law and literature. Weldon knew that her performances as a lawyer were winning her the publicity that was so vital to the success of her causes. Of course, when she argued her cases in court, she was not permitted to wear a wig and a gown, the professional attire of an attorney. The Life illustration, however, in which she is dressed as Buzfuz, but which has a caption reading "Mrs. Weldon," blurs the lines between fiction and reality. She looks like the real thing. When Weldon's 1959 biographer comments that, quote, "The Semple case confirmed Georgina's position as the most admired badgerer of lawyers since the death of Dickens," he touched on a key point about Georgina. More than a character, she was the author of her own legal story. In the courtroom, in her writing, in her public performances, she always was representing herself. And here is the real thing. Finally, in 1919, Helena Normanton was admitted as a law student to the Middle Temple. In 1922, she became the first woman barrister to practice in England. Carrie Morrison was the first solicitor. Cornelia Sarabji, an Indian woman who had studied law from 1889 to 92 at Somerville College, Oxford, also qualified for the bar in 1922. But I will conclude this part of my talk on my book before I talk about some newer things. I'm going to conclude with another representation, a representation of justice. The cover of my book is the cover image from an 1884 periodical that Georgina Weldon self-published. It's entitled Social Salvation. It is a very unique representation of justice, and it fits so well with my book on the performance of feminist jurisprudence in women's writing because she has books lying all around her. There are books on marriage law, libel, the lunacy law. But I also love the image. It's an attractive but not sexualized Victorian woman. It has the mirror, it has the broken chain, the hope and possibility it suggests. And it's actually Georgina. It's her face, it's her. One of the lost women whose inspirational legal advocacy I want to make known and celebrate. As a woman writer advocate myself, I'm also very concerned about issues of my present day. Intimate partner abuse, mass incarceration, economic injustices. It is important to me that my teaching and scholarship be about making a difference. So let's transition to the 21st century with another representation of justice. This is a painting by one of my former students, Chesha Dow. She was in my feminist jurisprudence class, and this painting is part of the project she completed in that course. I've been teaching feminist legal theory here since 2001, and since feminism is all about putting theory into practice, making a real difference, a requirement of the course is that students perform feminist jurisprudence in the community. This usually involves volunteering to work with a public interest organization for 25 hours on some special project. Over the years, students have worked with local immigration attorneys to help immigrant women complete applications for U visas, done research in connection with a class action lawsuit involving strip searches in Ohio prisons. They have worked on housing issues for Santa Maria Community Services, organized a letter writing campaign against the practice of shackling women prisoners during labor and delivery, compiled a cultural resource guidebook for the Alliance for Battered and Abused International Women, served meals at the YWCA's Battered Women's Shelter, and much, much more. Students, however, also may come up with their own projects that are a variation on this theme. That year, Chessa was incredibly frustrated with representations of justice. They were blind, aloof. She found the figure of a woman to be in some ways ironic in light of the injustices that women have and continue to suffer under the law. So she gathered images of justice, did interviews, started dialogues, wrote an essay, and ultimately created this painting. When she unveiled it on the last day of class, she explained that her original intention had been to write the case citations for various cases that had regulated women's bodies all over her in red. But as she stood there, paintbrush in hand, she couldn't bear to mark her, to mutilate her in that way. She liked this image of justice that she had created, and so she left her alone. While the thought was to hang this in the College of Law somewhere, instead it's been doing a great job performing feminist jurisprudence in my office for years. Other feminist jurisprudence projects over the years have included establishment of a pro se divorce clinic at Legal Aid of the Bluegrass. This is something that the director had wanted to do for years because there are many people who simply can't afford or don't know exactly how to get a divorce, so they don't. While Legal Aid wanted to offer this service, they simply did not have the time or human resources necessary to get it started. So one of my students did. One student got everything ready to go. She made arrangements with a judge to start a 2-hour session on a regular basis. She compiled all the necessary paperwork and did a training manual, and then worked on issues of outreach, how to get the word out that these services would be offered. Then another student, the next semester, he actually implemented the plan, holding the first 2 divorce clinics over the course of the semester. I am so pleased that this clinic continues today, although now Chase Law students actually run the sessions. But they hold a session each semester in each of 6 counties in Kentucky, and over 400 people have been served since the starting of this clinic. Another student, Jen Cuesta, helped to launch the Cincinnati Caregivers Circle Project. This project, funded by the Center for Community Change, involved the use of feminist organizing methods to engage formal and informal caregivers in community change efforts. Jen, all but single-handedly, designed the curricula for a series of 3 different small group events. Katie Hines, who's a community activist, is really the person behind this project. 12 different hosts used Jen's 3 series group events. So they held 36 small group discussions on the challenges and issues facing caregivers in our community. And in July, there was a caregiver summit where future action items were discussed, including how to move forward on the issue of low pay for caregivers. In less than a year, more than 115 people have become involved in this community building and action project. 2 years ago, I tried something different, with the entire class working together on one project. That was a lot of anxiety for law students, but they did a really good job. The Women's Fund of Greater Cincinnati wanted to produce a report on the cliff effect. The cliff effect is a phenomenon that occurs when a recipient of governmental support programs receives some increase in wages or a new job, a promotion, that can sometimes result in the fact that they go over a limit and their benefits get cut off. Even a small increase in wages can cause a precipitous fall, leading to really much less economic self-sufficiency on the part of the person. Over the course of the semester, my students worked with 9 different public interest organizations in Cincinnati to identify the various support programs that are available. Then they gathered data on all the eligibility requirements of these programs, conducted several interviews with women who had themselves experienced the cliff effect, and the Women's Fund then took the draft report that the students produced and has used it to springboard several economic self-sufficiency initiatives in the greater Cincinnati area. You'll see this. If you're on their list, you get their emails with this kind of thing all the time, but they're doing great work with it. Just as putting feminist legal theory into practice is central to my teaching, it also motivates my scholarship. In 2010, Verna Williams and I published an article entitled Social Justice Feminism. This article explored what it meant that many feminist activists, particularly women of color, who had made feminism their life's work, felt more than disillusioned with the feminist movement and its agenda. We begin this article with a powerful statement made at one of the meetings and retreats funded by the Ford Foundation to rejuvenate the women's movement, where one of the activists there said, "I don't want to do feminism anymore unless it's social justice feminism." In this article, we explore what that might mean, what a social justice feminist agenda might look like. In order to start a conversation, we propose 3 guiding principles and 3 methodologies, and part of the excerpts that you have talk more about these. We are very pleased that this conversation has taken off. We hosted a large conference here in 2002 with over 40 papers presented on various issues of social justice feminism. The new edition of the textbook that I teach in feminist jurisprudence now includes a section on social justice feminism. But closer to home, more personally, this article helped us to articulate what we wanted to be foundational to the Center for Race, Gender, and Social Justice, that my colleagues and dear friends sitting down here, always supporting me in the front row, Verna Williams and Emily Ho, co-founded in 2010 and currently co-direct. Through the center, we try to cultivate scholars and leaders and activists committed to social change. We have invited to campus women writers like Michelle Alexander, who has sparked a national debate and fabulous initiatives and campaigns regarding the problem of the mass incarceration in this country. And like my 19th century writers, she did it with a book, The New Jim Crow, Mass Incarceration in an Age of Colorblindness. Next fall, the center will be hosting the premiere of a powerful consciousness-raising vehicle on the issue of intimate partner abuse, the documentary Private Violence. We became a site for the launch of a nationwide movement that the filmmakers hope to inspire with this film, because one of our very own joint degree students, who's also sitting here being supportive of me in the audience, Unkyung Ho, is an associate producer of this film, which, by the way, was accepted to Sundance this past January and has been picked up by HBO to be shown in October, after our September premiere event. I also have to mention that Unkyung did a documentary film as a project for my feminist jurisprudence class when she was in it years ago. When Verna and I wrote Social Justice Feminism, we didn't know about the field of participatory action research, which actually has methodologies for doing the kind of bottom-up research and activism that we championed in our article. The idea of participatory action research is to collaborate with community stakeholders. Oh, this is a fancy Emily slide. Look at that, I have to push it. Is to collaborate with community stakeholders, those affected by the problem, to see what they identify as the issues and what they would like to do to solve the problem, as opposed to people coming into a community and studying it and deciding what people who are not part of the community think might be best. Currently, Professor Ho and I are engaged in an ongoing action research project on predatory lending practices in the Cincinnati area. This past year, we collaborated with Public Ally Cincinnati and AmeriCorps Leadership Development Program designed for individuals between 18 and 30 with the central goal of developing a new generation of diverse leaders. We sponsored, through the center, a team research project for a group of public allies that named themselves PowerShift. Some of the creative advocacy that PowerShift engaged in on the topic of fringe banking practice, such as payday lending, are... This is an example of a fishbone diagram. These diagrams are useful for honing in on an issue, moving from generalization, like a large topic like fringe banking, to specificity. You do this in a group meeting and people come up with different causes and contexts of the problem that you're exploring. This is a map of the locations of payday lending facilities in the greater Cincinnati area. This map, not surprisingly, shows particularly high concentrations in communities of color. On several Sunday afternoons, PowerShift went to Washington Park, spread out a Dropcloth, and invited people to draw about their experiences with payday lending. In your materials, you have a zine. We thought, since we were so much older, that we had a lot more experience and knew a lot more than they did. But we learned what a zine was, which the Urban Dictionary defines as a cheaply made, cheaply produced publication, often in black and white, which is mass-produced via a photocopier and bound with staples. This is a creative transcription of one of the many interviews that PowerShift conducted with users of payday lenders. It makes for a fascinating and thought-provoking read as the zine's words and images draw readers into the personal experiences recounted on its pages. And to circle around back to the beginning of my talk, here is a work of erasure poetry on payday lending. Erasure poetry involves handing out pages of text and asking the participants to cross out words such that the remaining words result in a poem. At first, we were using pages from a recent important work on fringe banking entitled Broke, but then copyright issues came up. What if we want to publish these? Do we have to use things? So we decided to use things in the public domain. And this poem actually came from the text of Alice in Wonderland. I'm going to read it. Down the rabbit hole. Tired of sitting? The bank? Having nothing? Conversation? What is the use? Hot day. Feel stupid. The pleasure worth the trouble? Nothing remarkable. Oh dear. Thought it over afterwards. Seemed quite natural. Flashed across mind. Another down moment. How to get out again. Falling. Fell. Wonder what was going to happen next. Great disappointment. Empty. Fear. Tumbling down, 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 ever come to an end? Wonder how I've fallen this time. Let me see, I think learnt several things. Lessons? No one to listen, no idea. Grand fall, was no one listening? Now, if we were participating in a community meeting on payday lending, we would use this poem to springboard a dialogue or on payday lending, or maybe we'd start handing out pieces of text to you and asking you to create your own erasure poetry. Although after today, I'm thinking I need to be handing out pages from Gloriana or Michael Armstrong, The Factory Boy, The Last Judgment, texts that are also in the public domain that I know about that too many people don't. But today, we're not here for that. We're gathered for a different reason. And I'd like to conclude with the words of a contemporary woman writer advocate, Patricia McGuire, a leading light in the field of participatory action research, whose own work and writing serves as such an inspiration to me. Patricia McGuire encourages, dig where you stand. She writes, the long haul work to transform reality, to change the world, to empower and liberate, starts with modifying the near environment. This means the organizations, institutions, and relationships in which we live and work on a daily basis. It includes the struggle to change ourselves in those near environments. In the face of deepening human poverty, widening economic and digital gaps, and numbing interpersonal violence, focusing on the near environment is not narcissistic luxury, but urgent necessity. Think about the tools that you possess to make a difference. Many of you are lawyers and educators, professions with skill sets that are invaluable to any social justice agenda. But consider, are you also a poet, an artist? Can you build things? Do you have good organizational skills? Are you a role model for a child? What in your near environment do you care about? How can you creatively make a difference? Because the social justice issues in our communities are matters of urgent necessity.